Boom. All right, ladies and gentlemen, I know sometimes you want to pull up a glass of wine, watch some 90 Day Fiance or Love is Blind for the drama, but we got one in store for you guys today. If you're in business and you've ever had to go through a breakup, or maybe you're anticipating one, you're going to want to pay attention to this episode. Let's get this one started. Here we go.
Shut up and sit down.
Look, a business can give you everything you want in life: prestige, wealth, freedom. It can also take everything away from you. This show is for those who are willing to take that risk. These are the real life stories of entrepreneurs. But before we start, I have one small favor to ask. Please leave a comment. It can be advice, critiques, tips, feedback, or share this with someone, because your engagement is the most valuable and most powerful form of social currency. So thank you, and welcome to another episode of Business Bros. Right, business bros. Now, he's the legal strategist you wish you called before the business blew up. From $1 million disputes to partnership drama gone wrong, he's helped entrepreneurs dodge disasters and take control of their companies. Please welcome to the show the one and only Mr. Joam Alisme. We can get the party started. Welcome to the program.
Well, thank you for having me. I'm happy to be here.
All right, let's get into it. Breakups. They're almost inevitable with a marriage, which is probably the scariest contract one can enter. We go into it blindly, and over 50% break up. I feel like in businesses, we often go in without a contract, just a handshake to get started, and things inevitably go wrong. Joam, welcome to the program. Tell me a little bit about your background and how are you helping people avoid big mistakes like partnering with the wrong person?
Absolutely. Well, to start with, I am Joam Alisme, like you mentioned. I'm a business litigator based in Brooklyn, New York. I have a firm here, and what we do is we practice litigation. We represent businesses, primarily entrepreneurs, in litigation matters involving breach of contract between the business and vendors or third parties, or disputes between business partners, like we we're mentioning. Breakups don't just happen in relationships, but they also happen in business, and they can be just as nasty. And we'll get into that as we have our discussion today. So we do that. We also represent shareholders in companies who are fighting against the board of directors, or if there's internal disputes between the members of the board and officers, we handle those cases as well.
So drama in the office, and we have to sort of filter through what's a red flag, what's not a red flag. So let's start with that. If I'm going to get into a partnership or I'm already in a partnership, what type or what are the top like red flags that I should probably be looking for, and what should I be doing about them?
Yeah, absolutely. So first of all, I'll give you a couple of red flags, but the main one that you want to look for when you go into a partnership or any kind of business relationship, whenever someone says, let's just do a handshake and let's not have any written partnership or operating agreement, you should run for the hills, because that's one of the main thing I see in my practice when it comes to litigating this type of matters. Usually the parties don't have a partnership agreement, or they don't have an operating agreement detailing exactly what their rights are and what their obligations are to each other. And so when we end up in court, we having to essentially rely on the court system. We rely on what the judge says or what the jury may say, as opposed to having actual agreement where you can actually protect your rights in a very detailed way. So partnership agreements is very important. So whenever someone says, let's not do one, that's a red flag. Number two red flag is you want to avoid working with people you don't know. Obviously, that's something that's quite obvious, but you'll be surprised. A lot of people, when they go into these partnerships, these business ventures, they sometimes go with people they barely know. Folks they probably just met over the internet, or folks they've not had a relationship with. So they don't really know what to expect from that relationship. And almost always down the line, that person ends up, going against them in some way or not honoring their word, and they end up in a litigation. So make sure you vet the people that you know. Make sure that you have a kind of a history or background with them, so that you protect yourself down the line. And another red flag I would mention to people is that when you're drafting these agreements, make sure that you have an attorney help you. Don't just rely on what you know, your own knowledge. You may be the smartest person in the world. If you're not an attorney, if you're not really well versed and educated in how to draft this agreement, you may end up hurting yourself more than you help yourself. So make sure you consult with an attorney. Don't just go out on website or the ChatGPT for information. Consult with an attorney to make sure that the agreement is drafted properly and that you're protected down the line.
Those are some cool 3 red flags. So definitely don't go into business with somebody you don't know. Make sure you have something formal, written agreement, operating agreement. At least you identify your roles in your company. And then when you're drafting that stuff, make sure you use an attorney. I know it can get expensive, especially at the beginning when you don't really have a business yet. You have more like an idea or a concept and something that you're going to do with a partner here and there, but you don't actually have a business set up yet. That's where the formal agreements tend to turn into handshakes. That's where kind of paperwork goes off. And I think we live in a pretty educated time. So with a quick little TikTok search, you're going to hear people say, oh, you're going to start a business. You should, form an LLC. And there are certain things that you need to fill out when you are creating an entity like that. But there are a lot of formal agreements that we skip. And you kind of mentioned them, operating agreement, things like that. What are those formal agreements that we have to put together, and how in detail should we get, especially early on when maybe the business is just an idea phase?
Yeah, absolutely. So you mentioned something that's very important and we should focus on. You mentioned the word expensive. So a lot of entrepreneurs and business owners, when they're starting out, they're concerned that an investment into their business might be too expensive at the early stage, and so they don't make it, and so they try to do it on their own, right? They don't hire that attorney that could give them the advice that they need, or they don't actually draft those documents that could protect them down the line because they think that they're saving on costs as opposed to making an investment. So what I tell my clients is that you should view the initial expense not as an expensive expense, but as an investment into your future, into your business, so that you're protecting yourself down the line. Because if you don't make these investments early on, when you get down the line to litigation, you may end up costing yourself a lot more money than you would have cost yourself initially if you made that investment. So in terms of what kind of agreements that you need, obviously when you're creating the business and you consult with an attorney, they'll tell you exactly what kind of entity that you need, whether it be an LLC, whether it be a corporation. They'll advise you on the right type of formation that you need. Obviously, you also need to have a partnership agreement if you have partners. You need to have an operating agreement as well. If you have investors in the business, shareholders, and things of that nature, you want to make sure those are properly drafted. And also, vendor agreements. If you're looking to hire vendors at the early stage to help you set up your business, and even if you're looking to take on contractors and eventually employees, you want to make sure that those agreements are drafted properly to include the language that you'll need to protect yourself at the early stage.
People don't really think about vendor agreements as much. When it comes to like a vendor agreement, usually it's something like a purchase order. You got 90 days out to collect the payment. And we kind of assume that purchase order, that invoice is kind of our agreement. But you're talking a little more in depth. When should a business owner kind of look at their vendors and formalize an agreement like that?
As soon as possible, because a lot of times nowadays, when you're engaging this type of vendors, a lot of times you are engaging with people who are in different states, different jurisdictions, and they may not have the same laws to abide by in their state as you do in your state. So you want to make sure that whatever agreement that you're drafting is something that reflects your own state's laws, right? And you also want to make sure that you account for what happens if there's a dispute, right? Mm-hmm. Over payment, over these responsibilities, what happens? A lot of business owners don't account for that. So you want to make sure that you have the proper language in your agreement to account for that. And you also want to make sure you designate where the dispute is going to be resolved. Is it going to be in your state? Is it going to be in your local courthouse? Or is it going to be in the vendor state or something outside of your area? So you want to account for that. So that's why it's important to make sure that those agreements are properly drafted. And you also want to make sure that you include timelines for payment. If there's any penalties for payment, late fees and things of that nature, you want to include all that information into your agreements.
Now, we obviously want to make sure we take care of all our formal agreements, identify our roles, our operating agreements, all that stuff ahead of time. But like I said earlier, there's a lot of companies that just don't do that. They find themselves in a situation later down the road as the business starts to grow a little bit, and you start to feel that awkward tension. Kind of when you're dating, everything's great when you're in that honeymoon phase, and then actual reality sets in. You have to make some hard decisions, and then you start thinking, is this the person I really want to be with for a while? In a relationship, that might lead to a breakup. What should business owners do when they first start feeling some of that tension between their business decisions and their partners?
That's a great analogy. It is exactly like dating, right? And a lot of times when I have these cases, the client come to me and tell me, listen, this person that I went to business with was my best friend. I've known them since college, or we grew up together. And this was always our dream to start this business together. And we started it, and we agreed that we didn't need a formal agreement because, we trusted each other and we believed that our trust would win out. And now, they're in litigation. The relationship is pretty much almost destroyed. They're not talking to their partner, and things are in a pretty bad state. So you ask, what should you do when you start noticing that things are going awry or stride? What do you do? The first thing you should do, and I counsel all my clients this, is potentially to try to resolve it amongst yourselves, right? Reach out to your partner if it's possible. If the relationship is still salvageable, if you're still potentially talking with them, reach out to them, try to have a conversation. And if you have a partnership agreement or an operating agreement, typically, if it's well drafted, it'll include language in there that states exactly how you can approach resolving the matter between the two parties, whether it be through mediation, which you can do amongst yourself, or you can have a third party mediator come in and try to resolve it between the two of you. And if that doesn't succeed, there's also the option to go to arbitration, which is a process that similar to going to court, but a little bit more cost effective in some ways and less time consuming, and also a bit faster as well. Whereas the court process can take longer, the arbitration process may be a little bit different. And the main thing that I would counsel to somebody who's noticing that the partnership or business relationship is going awry is to reach out to an attorney like us, business litigators who are well versed in these cases, who see these cases hundreds of times, know the pain points, know how to approach these disputes, and try to resolve them if we can before it gets to a point where the business potentially is at risk.
How can entrepreneurs kind of structure their operating agreements to prevent costly disputes? For example, when you have two partners, maybe one partner got into the business because they wanted to make a lot of money and then eventually stopped working. But you weren't exactly clear on what that looks like in your business. So maybe your business starts doing an okay level. You have one partner that feels like we're at a success point and they start kind of taking their foot off the gas pedal a little bit, while the other one's like, we're nowhere near where we need to be. You need to keep going pedal to the metal. And you start to kind of have these disputes. You're still kind of in the same roles. You're just not operating and working towards that same goal anymore. How can a properly structured operating agreement prevent some of these disputes where you, at the beginning, you had the same idea. We want to make a lot of money and then stop working as much. You're just not quite there in reality when it's happening.
Yeah, absolutely. So, our firm, we don't do a lot of drafting in these documents. We do some drafting, but the bulk of what we do is litigation, meaning we come in when the deal has gone awry, when one of the partners is looking to break up the partnership, or the business is at litigation, or one of the parties is being sued. But from our practice, what we typically see, the reason why folks get to the point of litigation, going to court, is primarily they didn't spend the amount of time at the early stage to sit down to talk about exactly what it is that each individual wants to get out of the business, right? You have to communicate with your partner just like you would communicate with your wife or your husband or your spouse, to be clear on exactly what the goals are. What is it that each partner is trying to achieve? Is partners looking to make more money and potentially be bought out in a couple of years? Is one partner looking to do most of the operations and not really focus on the sales side of the business? Is one partner is looking to be more of the front person and not be in the day to day? Are we looking to bring in additional partners, take on investors? So these are conversations you need to have early on, because if you don't have them, you're going to end up at a stage where you're at odds, right? If one partner is looking to expand, while the other partner doesn't want to do that, they want to add up more partners, and your partner does not want to do that. That's going to cause friction that could lead to litigation. And another thing that you should do is, again, when you're drafting these agreements, make sure that you consult with the attorney, number one, and that the attorney has the experience to make sure he or she accounts for all the language that you need in the agreement to protect you in case there's a dispute. And I think the number one thing you want to include in that agreement is try to resolve the issue through mediation first. If mediation does not work out, then you go to the next step. So those are what I would recommend.
There's a divorce attorney that shows up on my TikTok feed quite a bit, and he's got some interesting stories and insight into relationships, basically because he gets to deal with people when they're at that end of the rope and they're telling their story. You know, he did this, he's a horrible person, this is why we're splitting up. She did this, she's a horrible person, this is why we're splitting up. And I always feel like when it comes to that litigation side, there's always his version, her version, and then the truth. And somehow the courts need to decide what that truth is. I'm sure it's the same thing when it comes to a business. You get to deal with all these business owners who are coming to you when, shit's already hit the fan. The stuff's already bad. So you get, he did this, this, and this. He did this, this, and this. We need to amicably break up. How does a court in litigation determine what was actually true, what was meant in their operating agreement, and who gets what?
Yeah, that's a great question. And I think that's one of the things I like the most about being a litigator, because litigation process is set up to make sure that the truth a lot of time wins out. It doesn't happen always, but almost always, if you go through the process and you follow it thoroughly, the right party is going to prevail. That's because there are structures within the court system itself that make sure that each side gets a chance to present their case, right? It's not you said, she said. Both sides will get a chance to do that. When you file a case, you have to actually present evidence to support your case. And in this type of cases, partnership disputes and things of that nature, it's usually communications going to come into play. Email communications, documents, if there are any copies of operating agreements detailing exactly what the parties agreed to or what they didn't agree to, communication with third parties and things of that nature. All that information is going to come to light during what's called a discovery process, right? And there's also depositions. After you produce all the information, documents, and things of that nature, each side will get to depose the other side, meaning question that person under oath, right? You have to raise your right hand, take an oath, and you can't lie when you've been questioned. And that information can be used against you at trial. And of course, there's a trial process where you get to go before a judge or a jury and actually present your case. And at the end of that process, the judge or the jury will make a determination about who's right. So the litigation process itself is there to make sure that the truth wins out, not just he said or she said, but who's actually correct.
Now, in a divorce, for sure, there are a lot of emotions. There's love involved in those types of things. In a business, money can make people very emotional. And sometimes, my name's on the building, my name's in the company. I've put blood, sweat, and tears into this thing. There's huge emotional dynamics that are happening when a business is breaking up as well. How does that complicate the legal resolution process?
Yeah, that complicates it a lot, right? Because like you said, just like a normal divorce between a married couple, a divorce between partners, business partners, is really emotionally charged, because a lot of times these are people who've known each other for a long time, if they actually did the homework to begin with. And these are people who have long lasting relationships. A lot of times I've seen family members actually go into business together and end up in litigation. So these are really emotionally invested relationships. So my job as an attorney when I'm representing my client is to make sure that while we highlight the emotional side of things and wanting to get the resolution of that, we also try to make sure that we keep the ultimate goal, the client's goal, at the forefront. What it is that you're trying to achieve. Are you trying to salvage the partnership if it's salvageable? Are you trying to separate and go separate ways? Are you trying to be bought out? Do you want to be your shares to be bought out, or do you want to buy the other party out? What is the objective that we're trying to achieve? And let's use that as our North Star. Certainly emotions are great and they keep us going, but ultimately emotions are not going to address the bottom line because ultimately this is about money. Like you said, it's a business dispute. So let's focus on the practical. Don't discount the emotional, but also what it is that we want to achieve so that we can be more effective in making sure that we pursue that strategy.
Now, we've been talking for the most part when we have like a partnership. So these are two people that, went into business and then stuff happens and maybe they want to break up. But sometimes there's more than just two people involved. Sometimes you have shareholders involved and you have a dispute where, one business owner, like you were saying, maybe wants to get bought out, maybe is not doing things according to, I don't know, the way the board of directors is. For whatever, you have some sort of issue with shareholders and maybe a partner. How does that litigation process work when trying to resolve shareholder issues, and maybe without going to court? And then what does it look like if it does go to court?
Yeah, absolutely. So shareholder disputes is something that we deal with as well, because a lot of times shareholders are just as invested as owners of the business and the corporation because they've invested their money into the business and their time, and so they have an interest in making sure that the business operates properly. So oftentimes you have the leadership of the business, right? Whether it be the board of directors and officers, including CEO, CFO, etc. They're in charge to run the day-to-day operation of the business, but they have to do it in a way that is for the benefit of the company at large, but also for the shareholders who are investors in the business. And they have to do so in a way that's not detrimental to those interests. And we see cases oftentimes where the leadership of the business, the officers, take actions that could potentially be against the interests of the business, against the interests of the shareholders, whether it be engaging in self-dealing, potentially even taking funds away from the corporation for their own benefit, engaging in fraudulent behavior. When that happens, the shareholders, they have recourse, right? They can sue the leadership of the business on behalf of the corporation to potentially even remove those leaders from their position and to make sure that the core of the business and the business mission continues to move forward. And so they come to us. There's a process you have to follow, of course, to actually get to that point, including trying to resolve the matter before you go to the court process and give notice to the board. But if you're a shareholder and you feel that the board of directors or leaders of the business are engaging in behavior that is detrimental to the business and to your interests, we can represent you and get you the recourse that you need.
Now, in your line of work, you've been doing this for quite some time. I'm sure you got some amazing stories of some ridiculous stuff that's happened in business, as well as the everyday average stuff. On average, what's the common theme that you see that gets people into your office and into a situation where now they're legally having to dispute something and it has to go through the courts?
Yeah, so the common theme that I see when people come to me usually starts with a lack of communication. And that's usually in all type of dispute, whether it be a partnership dispute, a business dispute with shareholders, and the like. It's usually the parties that talk to each other. And if they talk to each other, they did so in passing. And even if they even chatted, they didn't actually reduce what they agreed to a document, right? So it's just in the air. There's no evidence of exactly what the details are. And because there's no evidence, then we had to make it up. And as you just said, people can make up their own stories and it ends up being a he said, she said. So the common theme is that people don't communicate and they don't actually retain legal counsel to help them through that process of making sure that their ideas, their hopes and aspirations are actually reduced to paper so that they can be protected. And when they get to us, obviously we do our best and we're well versed in doing that and making sure that they're protected. But that's the common thing that I see in this type of matters.
Now, I'm sure that for whatever reason, the universe kind of works out this way. When people need to find something, it shows up. Maybe there's going to be this clip that we take from this episode, and somebody's in a dispute right now. They're already feeling the tension. They know things are not going the way they initially planned. Their partner maybe is skipping out or things are changing. What can they do right now to protect themselves, to both legally, maybe even financially, and go, feel free to plug yourself in here. How can you help them?
Yeah, absolutely. So the first thing I would say is to reach out to a litigator like myself. My information is in the video area below. We are at alismelaw.com. That's our website. You can also contact me at my first name at alismelaw.com. So the first thing you should do is, if you're being sued, if your business is being sued, or if you feel that your partner is potentially taking steps to lock you out of the business, to not give you access to profits, and essentially taking charge without your say so, the first thing is to do, I would recommend you do, is to reach out to an attorney and have a consultation about how you can be assisted. Number two, the second thing that I would do is to make sure that you preserve any information that could potentially help you in the case, whether it be communication, like I mentioned earlier, emails between the two of you, any drafts of any documents that you actually started to draft or prepare. Make sure you keep those. Be communication with third parties and things of that nature. Receipts, text messages, WhatsApp messages. Make sure that you preserve those, because that's going to be the evidence you're going to use to support your case if that matter goes to court. Right? So make sure you preserve the evidence and reach out to counsel to make sure you protect it.
Yeah, it's a scary thing out there, especially when you get into that litigation phase. When you get served some papers, I know sometimes it's a panic thing. You want to react emotionally, but the best thing for you to do is find your own legal counsel. And Joam and his team are definitely out there doing this on a regular basis for their clients. So if you find yourself in some business drama and you don't want to end up on some Judge Judy courtroom type scenario, you want to get the real help necessary. You want to reach out to a real attorney, somebody who's actually been doing this for a while. Website is scrolling across the bottom. I'm going to spell it for you. ALISME law. That's LAW.com. That's Joam's last name. And make sure you guys reach out. Have that first conversation. I promise you, there are so many things that you think you know and you assume because you watch TV that this is the way it's going to go. And in reality, it doesn't always go that way. You want to talk to a professional, get yourself squared away and protected, because ultimately, at the end of the game, if you are not protecting yourself with an attorney and your contracts in place and everything in writing, I know it's expensive at the beginning, but you're going to be very surprised when you see the price here at the end if you're not protecting yourself. Joam, any last minute advice or final thoughts before we head out?
I think you said it perfectly. I would just emphasize again, make sure that as you start your business, you don't view the expense of legal advice and legal protection as an expense. View it as an investment, because you're investing in your future, you're investing in your business, and you're preventing yourself, your future self, from having to deal with a much more financially burdensome case than you would otherwise. So make sure you do that. And I'll also emphasize that if you've been served papers, your business has been served papers, if you notice that your partner is taking steps to lock you out of your business, if you notice that your company's leadership is acting properly, committing fraudulent behavior, reach out to attorneys like us, and we'll make sure that your rights are protected.
That's it, ladies and gentlemen. It's Alisme Law, ALISME law.com. Make sure you guys check it out. Go over there, get the protection you need, protect your business. It reminds me of real estate. I remember when I was first learning about real estate investment, the exit strategy is the first thing you think of before you go into that real estate investment. You know how you're going to get out of it. Now, life's going to happen and you're going to make twists and turns and turn left and right and do those sorts of things, but you know how to get out if that's the necessary necessary escape that you need to do for that particular investment. There's no different scenario that's happening in your business. I know you have big dreams. It's like getting a lottery ticket. You get a lottery ticket, you start a business, you start envisioning this future. You never envision the downside. That's why you got to protect yourself up front. Make sure you guys go to the website, alismelaw.com, alismelaw.com. Joam, thank you very much for being on the program. Ladies and gentlemen, that's all we got for you guys on this one. We'll catch you guys on the next one. Peace. And we're out.
It's over. Go home.
Is your business in need of marketing? Try starting a podcast. But not just any podcast. Podcast like a pro. We can show you how to take your business from being invisible to becoming a brand people trust. Go to www.businessbros.biz to get